Hi, I'm Stuart Salwin, and I'm a criminal defense attorney in Scottsdale, Arizona. And in this video, I'll be discussing the crime of underage DUI in Arizona. This is also known by criminal attorneys as a baby DUI. An underage DUI, or a baby DUI, is a crime that occurs when a person who is under the age of 21, so someone that's under the legal age to drink alcohol, gets caught driving a motor vehicle with alcohol in their system. For this crime, any level of alcohol will do, and this is one of the main differences between a regular DUI and a baby DUI, because for a regular DUI, to prove that crime, the state has to show that the driver either had a BAC above the legal limit in Arizona, which is a .08 BAC, or that the person driving was, regardless of the BAC level, actually impaired by the alcohol in his system to at least the slightest degree. A baby DUI does not require the state to show that the underage driver was actually impaired, though, and it doesn't require the state to show that the BAC was a certain limit. The driver's BAC could be a .01, which is barely any alcohol at all, but as long as there is alcohol in the driver's system, then they'd be guilty of a baby DUI. The Arizona statute for an underage DUI is ARS 4-244 subsection 34. This crime is a Class 1 misdemeanor, so it's a serious offense. A Class 1 misdemeanor is the highest level of misdemeanor, and it's the same level of crime as a regular DUI. This means that legally a person who is convicted of an underage DUI can be sentenced to up to 6 months of jail, $2,500 in fines, alcohol testing, community service, and any other terms of misdemeanor probation that a judge could impose for a Class 1 misdemeanor. However, there are two key differences between an underage DUI and a regular DUI. A regular DUI comes with mandatory minimum jail time and fines. If you're convicted of a regular DUI, then you'll have to serve at least 10 days of jail, 9 of which can be suspended, with alcohol screening. A baby DUI does not have mandatory minimum jail time, so a person can be convicted of an underage DUI but not have to serve any jail. Now, a judge can still impose jail if a driver is convicted after trial or if the driver pleads to the court, but the judge doesn't have to do that by law like they would if the driver was convicted of a regular DUI. Another key difference is that a baby DUI conviction under Arizona law requires the MVD to suspend that person's driver's license for a period of 2 years. So that's 2 years without a driver's license. This is not something that would occur by a matter of course with a regular DUI. There is some relief to this punishment, however, because the judge can, at his or her discretion, order MVD to give the driver a restricted license. And with a restricted license, the underage driver could drive between their home and school or between their home and their job. If a person gets a restricted license, they'll also be required to install a certified ignition interlock device on any vehicle they drive. And this is a device that's installed on the ignition of the car, and it's a type of breathalyzer, which requires the driver to blow into it before the car will start to prove to the device that there's no alcohol in that driver's system. If you have your license suspended because of a baby DUI, a restricted license isn't a guarantee. You or your attorney will need to convince the judge to order a restricted license for you. The court doesn't have to order MVD to provide you one just because your license is suspended as a result of a baby DUI. It's up to that judge's individual discretion whether you'll get one or not. So, what if a driver is both underage and their blood or breath test shows that they have a BAC above a .08? Well, in those circumstances, if the BAC is high enough, the state can still charge the underage driver with both a baby DUI and a regular DUI, or an extreme DUI, a super extreme DUI, whatever law is allowed by the level of BAC. And if aggravating factors are present, an underage driver can also be charged with a felony DUI. So a baby DUI doesn't preclude the state from charging other DUI offenses, which can also come with mandatory jail time or prison time in the case of felonies. But a baby DUI is just another crime that the prosecutor can charge the driver with, in addition to any other crimes that the state thinks the driver has committed. Now, let's talk about what can be done for a driver who's charged with a baby DUI. A baby DUI can be harder to defend than a regular DUI because the state has to prove a lot less. For example, showing that a driver wasn't impaired by alcohol is an important factor in most regular DUI defenses. But impairment isn't an issue in a baby DUI. The question is simply whether the driver was under 21, whether they were driving or in actual physical control of the car, and whether there was any alcohol in their body. So problems that the state will have in proving these elements of the crime can come into play in a defense. For example, the police officer, if he did not actually witness the person driving, that could be an issue. Or if the driver was already out of the vehicle at the time the police arrived, that can be a reason to doubt the driving element of the charge. And there can also be problems with the blood test or the breath test that the state uses to show that there's alcohol present in the driver's system. But beyond those factual issues, there can also be constitutional violations which can be used as a defense for your case. For example, a violation of the driver's right to counsel could lead to a dismissal of the charges. Likewise, if the traffic stop wasn't proper under the Fourth Amendment right against unlawful searches and seizures, and the court finds that a Fourth Amendment violation had occurred, then that can lead to suppression of the state's evidence that was gathered after the illegal stop, which is usually going to require the state to dismiss the case because they won't be able to prove it without any evidence. Depending on the blood alcohol content, if it's low enough, then your defense attorney may also be able to negotiate with the prosecutor to try to obtain a plea to a non-DUI charge, such as reckless driving, which wouldn't require jail time or a license suspension consequence like you see with a baby DUI. Now, the outcome for any case depends on the facts and what the state can prove, and no attorney can make any guarantees about your case. But having a skilled DUI attorney look into your case and fight for you can give you the best chance to get the best possible outcome in your situation. And if you're facing these type of charges and want to have a consultation on what my firm might be able to do for you, then please feel free to give my office a call. We offer free consultations on criminal defense matters. Thanks for watching, and I hope this video was helpful.